Perfect. Great. So thank you so much for joining us today. We are going to be talking about the £1 million mistake, so workplace discrimination and the impact that this can have on your business. So we're going to be going through the legal basis for discrimination so that we've got a basic understanding of the law and what we need to do as employers, and some things perhaps that you can be aware of. So the average discrimination claim for awards stands at around 44,000. So this is a huge issue that we are talking about. It's something that could be financially catastrophic for your business. And it's actually one of the least understood area of law, even if it is something that people talk about all of the time. There's lots of terminology that's thrown around without a true understanding of, one, what the legal terms mean, but also what our obligations are as employers. We are seeing an increase year on year in particularly disability discrimination claims. So we've seen a 30% increase between 2022 and 2024. So again, this is something that is likely to become an issue in most businesses over the coming years. So who are we, for those of you who haven't been on a session with us before? So we're HRoes. We're here to protect your business from the risk of tribunal, help you reduce your legal costs, and help save yourself from HR headaches. So whether you are a business owner or someone who is in HR and looking for some additional support, or a peer to be able to bounce things off, then that's also covered under the services that we do. So we have legal consultancy, HR consultancy, training, and we have our HR SaaS software product as well. So we're going to dive straight in. First of all, we need to make sure that we actually understand what discrimination is. So we're going to understand the legal framework. So we're going to talk about the Equality Act 2010, which is where our discrimination laws come from. And this is where that comprehensive protection for employees comes from. We're going to talk about the protected characteristics, because not everybody is protected from discrimination. We have to have one of the protected characteristics to be able to bring a discrimination claim. And we're also going to talk about financial risk, so what that can cost an organisation. And as we've seen in press reports and cases over the last few years, these can reach into the millions depending on the type of claim and what someone's losses or injury to feelings are. So the different types of discrimination. We've got direct discrimination, and we're going to go into these in a bit more detail as we get further through the session. But at this point, just to tell you what they are, we've got direct discrimination, which is when we treat somebody less favourably because of a protected characteristic. We have indirect discrimination. This is where we have a policy, a procedure, or a practice. The PCP might be something that you've heard lawyers talk about, that disadvantages someone with a protected characteristic, but it's neutrally applied across the workforce. Harassment, one of the most overused and misunderstood words in our employment law directory. This is unwanted conduct relating to a protected characteristic. Victimization, so treating somebody unfairly because they have made either a protected disclosure around something that's linked to the Equality Act, or have complained about discrimination. And then we've got discrimination arising from disability, so unfavourable treatment that arises from someone's disability rather than as a result of the disability itself. So there's a lot here. There's a lot of theory that goes into the foundation of discrimination. And we do hear people throwing the term around, say, I've been discriminated against, I've been subjected to harassment. Well, actually, there's a huge amount of legal theory here. So we need to be understanding when someone says they've been discriminated against or they're raising allegations of discrimination, what is it that they actually mean? What is it that has happened? Because if we don't understand this, we're not necessarily going to understand how we're going to tackle these issues or prevent them from happening. So the protected characteristics, so these are the things that are protected by law. They have an enhanced status under the Equality Act. So we can't pick on someone or be mean to someone because of their age, because of disability, because of gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex or sexual orientation. So where we have someone who says, for example, I am being discriminated against because I'm overweight, that is not a protected characteristic. Yes, bullying is wrong. We could investigate that through a disciplinary environment, but we're less likely to be at risk of a discrimination claim. We could still be facing perhaps constructive dismissal. But as we know, unfair dismissal awards are capped. There's a limit to what people can claim for unfair dismissal. If, however, you have someone who says, I am being picked on because of my disability, then that immediately has this elevated and extra protected status, and it opens up these uncapped awards. There is no limit to what somebody could be awarded in a discrimination claim if the business were to lose. So for any of these protected characteristics on the screen, so when I talk about protected characteristics, these are the issues that I'm talking about. These have that elevated status, and these are the things that we need to be bearing in mind when we're talking about those different types of discrimination claims. So looking at the poll, so asked, are you legally prepared when it comes to discrimination? So yes, we've reviewed our policies this year. So 50% of you, it's on our to-do list. No, we haven't updated in years, none, and not sure what's legally required. So this is great. Either we've already done it or kind of it's on our to-do list. So it's on our radar, which is great. That's really what we like to see. So we're going to look at some real world examples of where it has gone very, very wrong for employers. So there's the case of Eileen Jolly, and this was brought against the Royal Berkshire NHS Foundation Trust Tribunal. This is actually one of my favourite cases, which it shouldn't be, because for the last several years, exclusively I've represented employers. But this is one that really sort of tugged on the heartstrings for me. And this relates to an 89-year-old NHS secretary who had worked in her role since she was in her 60s. So really, really long service considering the stage of her life that this lady was at. And she was dismissed for allegedly not using computers correctly. Now, the background of the case is that she worked closely with a surgeon, and part of her role was to maintain the admin and the systems, which she was able to do. And she also maintained a list of people who were approaching the 52-week waiting point, so that this could be flagged to the internal teams. The internal systems changed, and she was put on training as to how her role was going to evolve. She was given a different job title without consultation, and was put on this training. The training was actually abandoned because the person who was delivering the training was unable to get the system to do what it was supposed to do, and the training was never picked up again. As part of a capability investigation, Eileen was taken through the various parts of her role that she was unable to do. She said she hadn't been properly trained, that it wasn't clear what her role actually was. And one of the real sort of pinch points of this case is that the person who is investigating her capability went out to talk to her colleagues to gather feedback about her performance. And overwhelmingly, that feedback focused on her frailty, her mobility, so things that were directly linked to her age rather than her actual capability for the role. The tribunal found that she had been unfairly dismissed and had been discriminated against on the basis of age, and she was awarded £200,000, which is one of the UK's largest age discrimination payouts. And the reason why this award is so significant is that typically when we look at discrimination claims, a large portion of those awards is often made up of loss of earnings, or when it comes to pension awards as well, that can often make up a huge amount of the award. This was someone who, by the time I believe it came to court, was 90 years old. So in terms of loss of earnings and loss of pension, those elements were relatively limited. So this really is a massive award when it comes to talking about injury to feelings and the effect that this had on someone. And the tribunal was prepared to recognise that in this situation. Now, the key lesson here is, one, adequate training, regardless of age. So the fact that this was kind of just skimmed through and they never went back to it for her was totally unacceptable. But also, when we are looking at capability and either there's a disability or an age-related element to it, in this situation, the gathering of that feedback and the focus on things that were associated to her age, so such as frailty and mobility, whilst those comments may well have been made with the best of intentions, were totally inappropriate and were not things that people would have said about a younger colleague. So if we're in a situation where we have got a capability issue, we need to make sure that we're not doing anything that either is discriminatory, that could affect somebody's dignity, and if there are reasonable adjustments that we need to make, that we are doing so. The second case is ACOM Limited and Malin case. Now, this was someone who was a job applicant. So he'd previously worked for the business, had left and then come back. And in the job application, he was having difficulties with the application form. Malin was someone who suffered with dyspraxia. I say was, he's still alive. I shouldn't have used that in the past tense. Malin is someone who suffered with dyspraxia, and he requested reasonable adjustments to the application process. And that reasonable adjustment was he wanted to give an oral application. He wanted to speak to somebody on the phone. The adjustments were refused, nobody rang him back, and he didn't get the job. The tribunal found that there was a failure to make reasonable adjustments on the basis of him suffering from a disability, which was dyspraxia, and he was awarded £2,000. So a relatively small award, but bearing in mind, this is someone who wasn't even an employee. This is just because of a faulty application process. And what the tribunal found was that the employer had reasonable knowledge that he was someone who had a disability, that they should at the very least have taken this process a little bit further along. They should have called him back. They should have explored more what the difficulties were and how they could potentially have supported him and what reasonable adjustments could have been put in place, rather than just stonewalling. So it's really important that we remember, and the reason why this case study is in here is that it's very easy to think about our existing workforce, not our policies and procedures around recruitment and onboarding. And if somebody in a recruitment stage were to ask for reasonable adjustments or to flag that they've got a disability, we need to be absolutely on our game when it comes to understanding the issues and what we may have to do for that individual to avoid a situation like this. Now, I say that the award was relatively modest, so it was only a £2,000 award. I think there was a £700 interest award as well. But this was a situation that was litigated. So this will have cost that employer thousands in terms of defending this case. So actually the global cost to the employer in terms of the management time taken to deal with this, the cost of their legal fees, and then ultimately the award at the end, for someone who never actually set foot in the workplace. This was wasted resources in respect of someone who wasn't an employee. So it's really, really important that we get to grips with these issues and we understand how we should be looking at our policies and procedures and making sure that they are essentially discrimination proof. So we're going to look at reasonable adjustments in a bit more detail. So there is a legal duty on employers to make reasonable adjustments or workplace modifications where we have someone who is caught as a disabled employee under the Equality Act. Now, for someone to be classed as disabled, they have a mental or physical condition that has or is likely to last 12 months or more and has a negative impact on their ability to undertake day-to-day activities or their workplace duties. So if we have someone who meets that definition, as an employer, we have a legal obligation to ensure that they are not put to a detriment in the workplace. There is actually a trigger for reasonable adjustments. So under Section 20 of the Equality Act, if we have got a physical barrier in the workplace that places someone with a disability at a detriment, we're under a duty to make reasonable adjustments to remove that physical disadvantage. So this could be, for example, where we've got a layout that isn't wheelchair friendly, or perhaps that we require people to walk a long distance from a car park to get into the workplace. There could be various physical issues that we need to look at. The second trigger is where we have a policy, criterion, or practice, so a PCP, like that indirect discrimination test, that places someone at a disadvantage. We have to alleviate that disadvantage through the application of reasonable adjustments. And then the third trigger is if we have got someone, if but for an auxiliary aid, they would suffer a detriment, we should be looking at providing that physical aid. So when we look at things like access to work and making adjustments to equipment or software, or perhaps even mobility aids and things like that in the workplace, that's where that comes from. So there's often a misunderstanding around reasonable adjustments that if someone presents with a disability, that automatically then there's this entitlement to reasonable adjustments. But we need to remember that Section 20 trigger. So whether there's the physical issue, the PCP, so the policy, criterion, or practice, or the but for auxiliary aids. The reason why I say to bear that test in mind is it can really, really help when it comes to structure around those reasonable adjustments. What we don't want is a scattergun approach where we just provide a list of useless adjustments that we say, well, at least what we've offered, because that's not going to be good enough. We need to think, what is the actual challenge this person is facing? What can we do to level that playing field so that actually this is an adjustment that makes a difference? Because case law has shown us just offering a meaningless list without consultation isn't going to get us past this hurdle, and we could still be on the hook for a failure to provide reasonable adjustments. So cost considerations, access to work schemes can provide financial support. So if your business is one that is going to struggle with this sort of thing, then access to work is definitely something that's worth looking at. We can also consider reasonableness. So if we rent a small office in a larger building, we're not expected to reformat the entire building to be able to apply reasonable adjustments. So we can still take into account size and resources of the business and whether we think an adjustment will actually work. And this is why occupational health is really, really important, because what we'll often get from a GP is, this is what someone's suffering with, but I can't tell you anything about how that applies at work because I'm not an occupational specialist. We refer to occupational health and they're going to give us much more detailed guidance in terms of what the difficulties are that somebody faces at work and potentially even suggest any reasonable adjustments. If they can't do that, simply by drawing attention to what the difficulties are and why and what someone might need in terms of assistance so that we can formulate that list of reasonable adjustments is going to be really, really useful. And when we're in that meeting then with the employee and we're talking about what we think is reasonable and what isn't, or what we can offer and what we can't, remembering it's not just a shopping list, it should be a very consultation-led process. So the employee doesn't necessarily dictate, but neither do we. We should be engaging with them. Well, what is the workplace experience like for you? What is it that you think you need? Okay, well, this is what we have in terms of resources. This is what we think we can do. What do you think of that? So it's a conversation where we're trying to come to an agreement about what may actually help this individual, rather than, and this is something I see all the time, an employee sending a shopping list and the employer saying, no, we can't do that because of X. It needs to be much more engaged and much more collaborative than that. So reasonable adjustment examples, so it could be assistive technology, so screen readers, voice recognition software, specialized keyboards to help remove barriers. Now, assistive technology is getting much, much more affordable. So I remember in a bygone age when I first started out in the legal world, digital dictation software was so expensive. And we were still in the world where we had little hand recorders. We would record what we wanted to dictate, and a secretary would pick the recording up and go and type it out and produce letters. Now, dictation software that will take that, provide you with your transcript and formulate things, they are all over the market and very, very affordable. So what 10, 15 or even 20 years ago would be something that potentially wouldn't be considered to be reasonable because of the expense is much more likely to be considered reasonable now. So if you have got people where assistive technology is likely to be something you need to look at, it's really worth getting out there and understanding the market, knowing what's available, what the software can do and how that is priced, and also what potentially government or local authority support you may be able to get to help you with that. Flexible working is also another huge one. It's one of the most commonly asked for reasonable adjustments. So this could be adjusted hours, compressed hours, working remotely, modified schedules to accommodate different needs. And again, not only is this something we need to be mindful for a reasonable adjustments perspective, but if we don't deal with flexible working requests appropriately under our obligations in respect of that area of the law, we could end up with claims coming from two different directions. One, a failure to provide provide reasonable adjustments, or also a breach of flexible working laws, or even then the detriment related claims where someone feels that they've been treated poorly because of it, for example, if they're taken through a performance management process. So this is really, really interwoven. This is quite complex stuff, and there's a lot of moving parts when we're looking at this area of the law. So if you have got someone who has a disability, they're requesting reasonable adjustments, flexible working's involved, and perhaps there's a performance management process going on, this happens all the time. It's a really, really common scenario. There are so many legal tripwires. It's really, really important that if you're not familiar with this area of law and you feel like it's starting to get a bit complicated, that you do take advice, because you could, for the sake of one or two decisions that you feel may have been bad decisions, be looking at your facing 5 or 6 legal claims because of that. We've then got additional support, so things like mentoring, job coaches, modified training. And again, understanding what is out there to support people can really help you to engage in these conversations properly. So rather than going into a meeting feeling a bit blank and not understanding what could be out there to help somebody, we'd want to go into this meeting having had our occupational health report, understanding what the challenges are, and maybe having done a little bit of research about what is available so that you can really engage in those conversations with that employee. So we're now going to move on to the other claims. So failure to make reasonable adjustments is one. The next we're going to talk about is direct discrimination. So the legal test here is where someone is treated less favourably because of a protected characteristic. Now, this is quite a high hurdle to reach. So what we're essentially saying here is, say, for example, we take someone who is pregnant and someone were to say, well, you're not getting promoted because you're pregnant and we don't deal with maternity in this business. That would be direct discrimination. We are treating that person badly because of that protected characteristic. We do require a comparator for this claim. So where you've read perhaps about cases or read in the press about direct discrimination claims, often we have this comparator reference. So this can be an actual person. So I was treated less favorably than that person, and I'm going to name them. Or we can have a hypothetical comparator. So in small businesses where perhaps there isn't anyone that someone can compare themselves to, they can create a make-believe comparator and say, well, if I'm claiming direct discrimination, I feel it is because of my protected characteristic. And even though this comparative employee doesn't exist, I'm going to create this profile to compare myself to prove my claim that I am being treated less favorably. The burden of proof here initially starts with the claimant. So they will have to say, I was treated badly. It was because of my protected characteristic. I can't think of any other explanation for it. The burden then shifts to the employer. And what the employer has to do is come up with a credible explanation, because if their explanation isn't credible to say, actually, yes, there is a reason why you were treated in this way and it's got nothing to do with your protected characteristic, the judge is going back to the claimant at that point and is likely to say, I prefer your explanation. Yes, I believe that is why you were treated in that way. So the minute that somebody has a case where they are saying, this is why I believe I was treated in this way, the shoe is on our foot at this point. We have to have a credible reason for why someone was treated in that negative way that is nothing to do with a protected characteristic, or we are potentially going down on direct discrimination. The other thing we need to be aware of is we cannot defend direct discrimination. If a judge finds that this has happened, there is no justification. There is no defense. We can't objectively justify why we behaved in this way. So direct discrimination is extremely serious. And this is where we can see those big awards, because this is where we have picked on someone because of that protected characteristic, and we're not given the opportunity essentially to explain ourselves. So it's very, very high risk. As I say, the risk of significant awards is much, much higher. It's a rarer claim because it is quite difficult to reach that threshold to show that I was treated differently because of this protected characteristic. But again, very high risk. So if someone is claiming direct discrimination, this is one of those where I would definitely say, if you're insured, ring your insurer. If you've got an advisor, a HR specialist, or a lawyer that you work with, this is something that you would want to flag to them. Next, we've got indirect discrimination claims. This is one of the more complicated aspects of discrimination. So we've got a provision, a criterion, or a practice. So this is a policy or a way of working that we apply to everyone. We do it neutrally. So we're treating everyone on the face of it in the same way. But in applying that policy, it disadvantages people who have a protected characteristic. So a really overly simplistic example that I often give here is, say, for example, we have an office where we have 5 floors and there's a lovely view of the city from the top floor. And the managing director decides, you know what, on a Monday morning, to get everybody's morale up, we want everybody on the 5th floor to take advantage of the view while we do our Monday morning team stand-up or town hall. And you have somebody in a wheelchair who says, well, that's all very well, but we don't have a lift in this building. I can't get up to the 5th floor. So we're issuing this instruction to everyone. It's a policy. We want everybody on the 5th floor for this meeting. But it is putting that person in the wheelchair at a disadvantage. Now, in those situations, if we can objectively justify our PCP, so our policy, then whilst there might be a finding of indirect discrimination, you're not going to go down for it because we can objectively justify what we've done and we satisfied a judge that it was a proportionate means of achieving a legitimate aim. In the example that I give of the meeting on the top floor, we're unlikely to be able to justify that as a proportionate means of achieving a legitimate aim. A judge would likely say, well, there's better ways to pick up morale rather than just having a view at the top of the building. So in these claims, the individual has to identify the PCP. They have to be able to explain what the disadvantage is and why it's because of their protected characteristic. We have to then be able to say why we can't say that's a proportionate means of achieving a legitimate aim. So where this routinely comes up is where we have performance management processes with people who have a disability. So in those situations, people will say, well, we have a policy around performance management. As someone who with a disability, I'm more likely to be absent from work and my performance is more likely to suffer. Therefore, I'm more likely to be caught under the formal processes and issued with warnings and also more likely to have my employment terminated. So we have our PCP, we have our disadvantage, and it's linked to our protected characteristic being disability. Employers will then say, well, we have a proportionate means of achieving a legitimate aim. Our legitimate aim is to manage performance. We're a business. We've got to be commercial. We've got to be able to service our clients and do what we do day to day. Is having a policy around performance management proportionate? Yes, it probably is. What's going to make it more proportionate is if built into that policy, we have reasonable adjustments available. So for example, stretching trigger points, allowing longer for someone with a disability to be able to come up to standard, or allowing more absences or longer absences before that policy is triggered. So indirect discrimination, particularly when we're talking about disability, often goes hand in hand with those reasonable adjustment claims. So it's a little bit more complicated. There's a few more steps involved, but this is where it's really important that where we are applying policies, that we are bearing in mind where they could be discriminatory, who they could disadvantage, and how we're going to level that playing field in case we are challenged on it. Next, harassment and victimization. So harassment, which hopefully you're all really familiar with now because we sort of should have done our e-learning on sexual harassment, because sexual harassment is part of wider harassment claims. This is where we have unwanted conduct that's related to a protected characteristic that violates someone's dignity or creates an intimidating, hostile, degrading, or offensive environment. It can be physical, verbal, or non-verbal, and intention is irrelevant. It's the impact that matters. So where this really comes into play is where someone says, oh, I didn't mean to offend somebody, it was only banter. As we should all know by now, that's not a good enough explanation. That can still be harassment. The key here is, though, and why this word is so overused and often misunderstood, is someone says, oh, I'm being harassed, the environment is being made intimidating for me, but it's got nothing to do with a protected characteristic. If the behavior is not related to one of those 9 protected characteristics, legally under the Equality Act, it's not harassment. So unpicking this, particularly in the context of bullying claims, can be quite complicated. So it is important, if you've got someone alleging harassment, you don't understand where they're coming from, that actually you scope this out before you start making decisions over whether somebody has been harassed or not. Victimization, so this is where we treat someone unfairly because they've made a complaint about discrimination or they've made a complaint under the Equality Act. And this can be as small as having reference to their line manager that they feel that they're being discriminated against. It doesn't need to be a full formal written complaint. It also covers people who have brought tribunal claims. So if somebody suffers some sort of retaliation, then that is likely to be victimization. So when we're talking about whistleblowing as well, this again is something that we need to be really, really mindful of. So let's have a look at the employment tribunal process. So if it all goes wrong in the workplace, you can have someone then who will open an ACAS early conciliation. You may not even be aware that somebody has done this. So a claimant can open ACAS early conciliation and tell the conciliator, oh, I don't know why the fireworks are going off. It's probably because I'm gesticulating too much. They can open early conciliation and say, I don't want to negotiate, I don't want to mediate, I don't want you to talk to the employer, I just want my certificate. Once they've got that certificate, they then can bring an employment tribunal claim. So they start their ET1, their claim form, and that's got to be submitted within 3 months of the incident, taking away the period for ACAS conciliation. So what somebody could do, for example, is say they were discriminated against on the 1st of January. They could open ACAS conciliation within 3 months, so on the 31st of March as being their final day. They could sit on that ACAS conciliation process for a month, 6 weeks, and you've no idea it's going on. At this point, you're getting into May. So you're thinking 3 months has passed, no tribunal claim, I'm home and dry. They then can take a further month because the ACAS conciliation period has stopped the clock for that month. They then have the month to put their claim in. So it may not be until even July, potentially August, depending on the tribunal that you're dealing with, because they're so overwhelmed administratively, before you're aware that a claim is even being brought. So it's a very long process, and this is going to get even longer because what's clear coming out of the Employment Rights Bill is that limitation period of 3 months is going to be extended to 6. So you could be looking at up to a year before you know that a claim is being brought against your business, potentially even longer, because we're going to see a huge uptake in the number of claims once we get those day one employment rights, and the tribunal are just not set up to deal with that volume of claims. They're already dealing with massive backlogs, which is why their administration process for turning things around takes so long. So it could well be that you're having to answer allegations from something that happened a long time ago. So we have witnesses who may have left the business, people who can't remember what actually happened. So it's really, really important that we have our internal processes set up so that we are encouraging people to tell us when they feel uncomfortable, if they've been feeling discriminated against, that we're documenting these meetings, that we are taking witness statements, so that if we end up in this tribunal process, that we're not scratching our heads a year and a half later going, well, actually, Judge, I'm really sorry, but I can't remember what happened. Because when we think about that burden of proof from direct discrimination, if we don't have a convincing explanation other than the claimant's version of events, we're going to go down on one of these claims that could cost us hundreds of thousands of pounds. Once we get that claim for, we then have the chance to do our response, that's the ET3. And often with discrimination claims, we then have a preliminary hearing where a judge will set out the list of issues, decide how the claim is going to be managed in terms of, when we're doing document exchange, when we're doing witness statements, and potentially even set a date for hearing, and then we have full hearing. So from getting that ET1, from getting the claim form, you may not be in a tribunal hearing for up to 2 years. Now, there's some employers who say, well, actually, then that creates a tomorrow problem. Today, I'm trying to pay my national insurance, keep up with the national wage increases, and deal with all the fires within my business that are happening day to day. I'm going to sit on this, let the tribunal process kind of do its thing, and worry about the hearing nearer the time, or worry about the legal expenses nearer the time. Or it could be that where you're dealing with a litigant in person, so a claimant who's unrepresented, that actually the tribunal process becomes not only painfully slow, but painfully involved, because that person, with not having a legal representative, does not know how to navigate a tribunal process. So you get dragged into a huge amount of correspondence and engagement throughout that process that can be very, very distracting and very, very draining. So again, it's really important that we are set up internally for when this happens. Who was our advisor that was helping us deal with this? What documentation can they do so that we are tribunal ready, so that when we're handing over to a legal team, that we can go, here's the file, please deal with this and let me know when you need a witness statement from me, rather than having to get super involved in something that's going to be very, very draining, or that's going to keep us up at night. So in the next poll, have you made reasonable adjustments within your business? Yes, we're very confident, we're proactive, that's brilliant. Somewhat we try, but we could improve, and then we haven't got a response and not confident, or didn't know that it was a legal duty. Thankfully, that's really good that we've got no one who didn't know it was a legal duty. But certainly in terms of that, we try, we know we could improve. It's definitely something that I'd suggest that you should be looking at your policies and procedures, the way that you work, that you think, actually, if we got a tribunal claim tomorrow, are we ready to defend this? Do we understand what's gone on in the various pinch points in our business? Do we know our policies and procedures well enough to be able to say, yes, Judge, we looked at this in the context of discrimination and thought, how can we make this so that our workplace is more accessible to everybody and that we're treating everybody with equity? And training, again, is super, super important to this. And it's why our next e-learning program that we're coming out with is DE&I. So this isn't around those political programs or what we're seeing in the press. It's around making sure that people understand how they should be behaving in the workplace, how they should be behaving with their colleagues, so that they understand where the standards of behaviour are, so that if you have someone who is accused of bullying, the case looks like it's proven, that somebody can't then say, well, actually, I was ignorant. I didn't know that I couldn't do this because I didn't understand that my behaviour was discriminatory. We're removing that entire argument so that we can try and elevate behaviour within the workplace, but also protect you and your bottom line. So financial implications, as we've said, the average award for discrimination is around 44 grand. We are seeing awards going into the millions, particularly where we've got people who have got long loss of earnings, career losses, or large pension claims. Your legal fees could be around 35,000 or more. So one of the last major claims that I dealt with in private practice before I founded HRoes, the legal fees were over £100,000 for solicitors, and 50 grand was spent on barristers. And that was a claim that ran for 5 years. And we were in tribunal for a month. So if you think about wasted management time, if you think about resources for the company, not only financial, but in terms of people involved in that tribunal and how distracting it was, they won. Thankfully, the individual was claiming £1 million, but the company won, so there was no liability in that respect. But it took a huge toll on the business in terms of those legal expenses and also the management time that was involved. So there is a limitless impact for your business, including reputational damage if you were to face a claim of this type. So prevention strategies, we need to be thinking about clear policies, so comprehensive anti-discrimination documentation, going through our policies and procedures, thinking about that indirect discrimination and our reasonable adjustment obligations, staff training. I go on and on and on about this because so often when I'm advising on a situation where things have gone wrong, often it comes down to ignorance of either a line manager or someone who doesn't realise that actually what they're doing is unacceptable. So regular awareness, compliance and education. Auditing, so thinking about our practices, thinking about how we're working day to day. Is there any way that we can improve, adapt and evolve? Even if it's planning around things like, well, we haven't had a flexible working request yet, but if we got one, this is how we would deal with it. This is where we think we can be flexible within our workforce. And then that open communication. Complaints and grievances can feel like an absolute pain, but trust me, it's less painful than a tribunal process, particularly one that comes after so many months. So being able to deal with things and get your hands on a complaint and get to the bottom of it has so much value in terms of your preparation, because you may have a situation where you think, you know what, regardless of what we do, we know this person's going to sue us, and that does happen, and you can kind of get a bit of a, well, you know what, what's the point? There is so much that we can do here in terms of insulating ourselves against that litigation process. So taking really detailed witness statements, engaging with a lawyer so that we're getting advice on how we can best present ourselves and make sure that we're setting ourselves up for success. So training and awareness, we can train managers, so we can do workshops on discrimination risk and identifying mitigation tactics and how to approach reasonable adjustments. There's training that you can do on unconscious bias. So this is a really big theme at the moment that we're seeing, and also a really popular training area. Things around inclusive leadership, but then also across our workforce in terms of standards of behaviour as well. And if you are going to engage with training, make sure that you're getting good value for money and that at the end there are formal assessments and that you are getting that CPD accreditation as well, which we're really pleased to be able to offer with our training in either the face-to-face environment or with our e-learning platform as well. Make sure that we are retaining documentation and evidence. So anyone who's ever been on a training course with me will hear me say again and again and again about documenting things. When we have conversations with employees, keep a note of what was said. Informal meetings, take formal minutes. Make sure that if something happens, we are promptly taking witness statements from people. We're interviewing people to get to the bottom of what's gone on, and we're keeping that documentation because it really, really is invaluable when it comes to tribunal. And it's something that I say again and again, tribunals are won on documentation and they are lost on witnesses. The minute that you put somebody in a witness box, even if they think that they've watched loads of Judge Judy or Judge Rinder or whoever it is that's on television these days, and they feel that they could stand up to a snappy barrister, trust me, it's a very, very different environment when you go and do it yourself firsthand and experience sitting in that chair. Witnesses can make a terrible mess of things. Barristers are trained to tie people up in knots. If you have clear documentary evidence that is irrefutable, it's there in front of you in the tribunal bundle, that is very, very powerful evidence. And it's much, much better to be relying on documentation and evidence rather than hoping that you can clean up something in a witness chair, because it almost never makes things better and it often makes things worse. Neurodiversity, so this is a huge subject at the moment. It generally has legal protection. So conditions like autism, ADHD, and dyslexia receive disability protection very, very quickly. So where you have someone who is saying that they have a diagnosis, my standpoint often is, even without applying the legal test, if we treat it as though it is a disability, we're more likely to be erring on the side of caution and we're less likely to be criticised. What we're going to be seeing more of is we're seeing more and more pushback regarding over medicalisation of terms, particularly with this being a political issue as well, is people then strictly applying what is a legal test, not a medical test. Is it a physical or a mental condition? Has it, or is it likely to last more than 12 months? Yes, it's likely to tick those boxes. Does it have a negative ability on someone's ability to carry out day-to-day activities? Now, this is where there is a huge amount of question around these conditions because they are experienced in varying different degrees. Where you have someone who is able to continue an essentially normal life, but requires small tweaks and adjustments in terms of things like communication, there is a chance that it may not pass that legal test. Now, this depends whether it's that's the hill that you want to die on, whether you want to be arguing for 2 days in tribunal over whether something actually is or isn't a disability. It's often used as one of the initial protections. So there'll be a preliminary hearing to decide if someone is or isn't disabled, and then the rest of the claim falls away if they're found not to be. But if you are going to do this and you're going to engage in that, I absolutely would take the advice of a legal expert. Absolutely utilize occupational health as well, so that we can really understand what the day-to-day implications for someone are for their condition. Because if we go down the route of, well, no, I don't believe that you're actually disabled because of this, this, and this, and we get it wrong, we are raising that legal risk. So this is absolutely something that should be done in conjunction with an experienced advisor. In terms of common adjustments, there's often some very quick wins that you can implement. So things like quiet workspaces, adjusted communication styles, training for people, assistive technologies and things like that. So before we just kind of rule it out, perhaps think about, well, are there any adjustments that we can make generally to the workplace? Because people with neurodiversity are often extraordinarily valuable employees who can bring a very different, often viewpoint or level of expertise into a role. So I wouldn't be looking at this as something that's seen as a bit of a pain. This is something that we should be embracing actually as the potential for a huge amount of positivity. And updating our workplaces, looking at these easy adjustments, and we could be then adding a huge amount of business benefit into our business by embracing this. So risk management, you should be thinking about the risk areas within your business, whether it is recruitment, promotion, workplace conduct, or if you're looking at restructure or redundancy. Be wary of the warning signs. So think about biased job descriptions, lack of diversity in leadership, insensitive comments or exclusion, or the way that people behave. And that's often a real pinch point. Individual behavior within workplaces, this is why we prioritize training, is super important. And then making sure that anything we do isn't disproportionately impacting on protected groups. So our last poll, what's the biggest risk do you think in your business? Do you think it's tribunal legal fees, reputational damage, staff turnover due to culture, or actually, no, we're super confident in our prevention strategy? Tribunal legal fees, yeah, reputational damage. As we're aware, the press take a huge amount of interest in discrimination claims. So reputational damage is something that can be really real. That's great that we've got someone who's confident in prevention strategies as well. That's really, really pleasing to see. So creating inclusive culture, how do we do that? So making a leadership commitment. So senior executives should be visibly championing diversity and inclusion initiatives. So this isn't around that token or virtue signaling. Don't get me started on the Blue Horizon or whatever it is, that ridiculous space trip this week. I am going to be, sorry, Dawn, I am going to be all over LinkedIn about that this week. I know I shouldn't be talking about it, but that really winds me up when we've got essentially virtue signaling and that sort of flavor when it comes to DE&I. What we should be thinking about, how can we treat people equally, fairly, and with dignity in the workplace, that we don't discriminate against people, that where we can make reasonable adjustments, we do so, that we don't have ridiculous initiatives that make us look great but don't actually do anything, and the reality is reduce the dignity of these people that we're supposed to be helping. That we have a zero tolerance approach, where we are swift and consistent where we see discrimination happening, and we nip it in the bud, and that we create an environment that is psychologically safe. that we have support groups for different communities, so that we have the ability for people to be able to speak up if something is wrong, if there is something impacting them, that they can speak up and that we take it seriously, and that we can measure progress. So we can take data, we can do data collection, identifying gaps and tracks and improvement. Even if you don't have to monitor equal pay because your company isn't of a size where you need to do that, it's a really, really valuable exercise to be doing those audits around pay as well, to make sure that we're not inadvertently falling into that trap around not paying people what we should be doing, either because we've got into a cycle in terms of recruitment, so it's pushed up certain pay elements, but making sure that we are treating people the same and with equity in the workplace. If you need anything else, here's our shameless plug. Please don't hesitate to tune into our HRER podcast. So we are a top 20 UK HR podcast where we deal with lots of real world HR emergencies with life-saving advice. And if you are interested in any of the services that we offer, so we offer HR consultancy, HR software, training, and if you are a HR consultant, we also have white label solutions as well. Please don't hesitate to reach out and ask us for support or ask us for more information. That wraps up this session. It is a bit of a longer one this week because it's such an in-depth topic, but hopefully this has been really useful to help you with your understanding around discrimination. If there's anything else that you need, please don't hesitate to reach out. But that does conclude this webcast, and thank you so much for your time and your attention this morning.